If you have not mentioned your foreign or Canadian work experience in your previous study or work permit applications, that may lead to your PR refusal. So today we're talking about the avalanche of procedural fairness letters, as we call them, PFLs, and outright refusals for express entry, mostly for express entry permanent residency applications, due to immigrants or applicants not mentioning work experiences in their previous study or work permit applications.
Yeah. Yeah, it's a bit of a pandemic of refusals right now. Uh, talking on consultations with a lot of people, and even just getting emails and messages from a lot of people who that getting refused. I got a refusal and panic, right? So yeah, it's becoming more and more apparent that what IRCC is doing is purposefully finding mistakes in applications and refusing them, sometimes outright just refusing them, in some cases requesting more information, in some cases procedural fairness letters so you have a chance to respond, and in some cases some procedural fairness letters not even allowing a response, just an outright refusal. Here you go. So yeah, it's becoming more and more common, and people just need to be very careful with their applications right now. Dot all the I's, cross all the T's, double check that all your information is correct. And, we're talking about using experiences that you haven't claimed in the past. So there are some things that you can do, which we'll talk about, in terms of not ever explaining before, I was working for 3 years back home, but then all of a sudden on PR application, you have 3 years experience, and you've never mentioned it on previous study permits. You've never mentioned it on previous postgrad work permit or any other applications, TRVs, whatever it might be. And now all of a sudden here it is, right? So that's what I think it's becoming more and more common. Yeah.
Yeah, for sure. So we're going to show you guys just an example of how that letter may look like. So the example we're going to show you in a minute, that's a procedural fairness letter example. So what is procedural fairness is basically when IRCC has very serious concerns, and usually that pertains misrepresentation, then they would issue procedural fairness letter to give you opportunity to address those concerns before IRCC make that life-changing decision for you, right? Now, that being said, I'm going to share the screen right now, but that being said, it's not always that you will get procedural fairness letter. Sometimes it's just, as we said, outright refusals, and they just don't give you opportunity, and they just say that, okay, there is no misrep, but we are refusing your application. We had just yesterday somebody reaching out to us with that kind of refusal, and we're going to share the screen to show you an example so you know even how it looks like and what you can expect. So this is an example just taken from one of the online sources, but it's just to show you how things look like. So if you go to the top of this letter, it's a procedural fairness letter, and it's just basically saying that, we're concerned that you may be inadmissible for representation because you have provided contradictory information related to your employment history. And that's specifically what we're seeing all the time right now. On your application for a work permit, you listed employment at this company in the position of so-and-so. On your express entry application submitted on the date, you listed employment at the company from different dates. So there is no mention of so-and-so in the employment in the application. So I'm not actually... There is, what I'm assuming here, there are 2 employments, okay. And then one of the employments was just period not listed. So we're actually seeing a couple of different things right now. So one thing is the fact that people just didn't mention employment period, right? Another thing is what we're seeing is that some people mention different dates, right? So in both cases, that can be the problem, right? And then basically, there is a second page to this, but I'm not going to bore you with this, but basically the government is giving you opportunity to provide any document, and they're not telling you what documentation. They're just telling you provide anything that you think can be useful for us to make a decision. Otherwise, it will be a misrep. Yeah, so let's talk about, like, this is kind of how it looks like. So let's talk about what people can do in these situations, because we know as immigration
Yeah.
consultants that literally almost every person we talk to did not mention their experiences in one application or all
Or another.
applications. So yeah.
So yeah, that's the first thing to do is to, number one, hopefully you can have access to your previous applications. Hopefully you know what you submitted. I know people say like, well, I can't remember. I was so long ago. I know that might be the case, but you need to try. If you used an agent or if you used another representative, go back to them, see if they have your information. If you did it yourself, check your computer. Find out what you submitted information wise. That's the first thing, is to find out if you're going to be potentially contradicting yourself when you submit your PR application. Have I mentioned this? And if you know you haven't, there are things you can do. So as Olena said, like part of that procedural fairness letter that she just showed, they are asking for documents. So right away, like if you have this kind of scenario where you might have had not mentioned previous employment, the more documents you can provide right now to back it up, to prove it, the better, right? So if you just included an employment letter, and here's my employment letter, and I was working back home and that's it, and I never mentioned this before, most likely that's going to be an issue. That you're providing the bare minimum. Don't do that. Provide everything you can. Go back to that employer, say, look, I need documents. I need, whatever you can provide, job offers, relieving letters if you have them, pay stubs, tax documents, bank statements showing the funds going in. You should provide everything up front, right? That's the first thing I would say, is that to get out in front of it, right? Don't allow it to become a question in IRCC's mind and then possibly have to respond to it. Instead, address it out front. Do your best to prove that experience, even if you haven't. And you can mention that, I was not trying to hide anything, and you can get out in front of it. And I think that's a good plan, is to say like, look, I've never meant to hide any information. I had not mentioned this on my previous application because I thought, a lot of people say, I thought when I was applying, they only wanted Canadian experience. That's a common thing that people say, and that's fine if that's the truth. Say that, and then provide as much documents as you can to prove that employment. The other thing is double check that, when you Google the company, that there is a online presence of this company, that if you're using, like, for example, experience back home, I would recommend Googling, because IRCC will Google it and they will find out if there's like no online presence, another red flag, right? So make sure you can you understand, that do what IRCC would do your own, inspection of your own application. And yeah, I would say try and get out in front of it now.
Yeah, for sure. And another important factor in this is whether this experience was not mentioned in all of the
Yeah.
applications or just one, right? That's a very important factor, because most of you guys who are applying for express entry, you previously filed study permit, postgraduate work permit, and at least one TRV, which is a sticker in your passport. That's usually what we see. So you had 3 opportunity in every single of those applications to mention your experience. So that would be our first question, is figure out, as Cory said, like what was there, because probably you don't remember. Then second is that we need to see whether it was in all applications or just in couple or in one. Because if it's not mentioned everywhere, then yeah, that's more concerning for sure, but you can still get kind of ahead of it. Another thing is that what we do, and I know it's maybe not like applicable to all of the do-it-yourself people, but we do rely on case law. There were court decisions that pertain this particular situation that would actually make your case stronger. We can cite those court decisions to really show IRCC that this can be still a favorable decision potentially, right? So yeah, so we would encourage you to really take it seriously. And unfortunately, in 2025, you have to assume the worst. So be prepared. I don't remember. It's not a good reason for it's just not a good justification for IRCC.
Exactly. And hiding it or just like hoping it doesn't come up is not a good solution, because that's a lot of people's first instinct, is like, I'm just going to apply and hopefully everything goes good and I'm not going to mention anything, and I'm going to just, do the bare minimum and hope it goes away. That's not a good plan to do either.
Well, it's a luck of the draw, right? It's like playing the roulette. Yeah, you can do
Yeah,
that. And then it's a strong 50-50 chance it's whether going
exactly.
to be approved or you're going to get misrepped for 5 years from Canada, right? So
Exactly.
if you're willing to play Russian roulette, that can be the case. But usually the better plan would be to really, really get ahead of this, especially just with the volume of those letters that we're seeing right now, with the amount of like we literally have on Instagram, like every single day, people messaging
Yeah.
us. I got my PR refusal just right now. Can I urgently book a consultation with you? Because I didn't mention it in my study permit or work permit or whatever.
Yeah, and I just want to mention that this is new. This is not like, this is not because, the IRCC changed the rules or anything. It's just that wasn't enforced back in, let's say, 2023 and 2024. A lot of the times it was just like a blind eye to it and people were getting approved. Well, those days are over. And, every so often IRCC starts enforcing things that they haven't been. And that's where we're at right now. So, don't think that like, oh, my friend was good in 2023. They didn't mention it and they were fine. Yeah, okay, that may be true for 2023, but now we're in 2025. It's a different ball game.
You know what? That's a very good point. That is a very good point because that's how we think about our
Exactly.
clients and our applications. Because previously, we've been practicing for 8 years, and previously we might have taken a little bit of a different approach. When now with our clients, we have clients in this situation. That's what we do literally every day. We are taking very, very serious approach when we're really justifying getting ahead of the game and really taking it seriously, which probably we wouldn't be doing like back, in 2020,
Yeah,
2021 or whatever.
exactly.
Yes. So yeah, that was really good point. So be careful, guys. And thank you so much for watching this episode. And please watch our other videos and subscribe to our channel.
Subscribe.
Yes. If you want to ask us any questions, ask them in comments and we will answer them.